prosecutor to become specially authorized to appear in federal court so that we can assist the AUSAs in federal prosecution and get more people federally prosecuted who might not otherwise be. So I'm going to transition now to the quick update on Title 14. There are 3 areas that are being updated in Title 14. Title 14 has not been updated since before 2009. The DUI statute has not been updated since the late 1980s. The vehicular homicide statute of limitations is 3 years. Statute of limitations, as I mentioned earlier, for misrepresentation of novel produced goods or products is 10 years minimum. It could actually be longer. Some courts have thrown out traffic citations issued by cross-commissioned Arizona DPS troopers because they're not prepared on the physical traffic citation ticket that NPD officers use. So several of the fixes that we're trying to do include fixing some contradictions in the DUI statute. For somebody who's convicted a second time of a DUI within 24 months of the incident date of the first DUI, there is a sentence. It's part of 707F, and there are multiple sentences, as in sentences containing words, in that 707F. One sentence says you have to be sentenced to not less than 30 days in jail for your second DUI, but then the next sentence says not less than 90 days. So it has an internal contradiction, and we are hoping to fix that issue. The vehicular homicide statute, we're hoping to raise to 6 years, and we are hoping to write a special provision into 14 NNC 806 that would say that if you are a cross-commissioned trooper from another law enforcement agency, use whatever citation system you normally use. Because, God forbid, an AZ DPS trooper is the primary officer for vehicular homicide, and the court throws out his citation because it's not to their standards and to what the law says. I think I went maybe one too far. There we are. Key things to consider with Title 17, Part 1. The statute of limitations for the intentional killing of another Navajo or another person is 3 years. The statute of limitations for forgery is 10 years minimum. The statute of limitations for raping a 10-year-old Navajo child is 3 years. The statute of limitations for obtaining a signature by deception is 10 years minimum. I understand that white-collar crimes are important, but I would put aside white-collar crimes every day for punishing those who rape Navajo children. The Navajo Nation likes a strangulation or suffocation statute. Strangulation is one of the most lethal ways to inflict violence. The vast majority of stranglers are men, and the vast majority of their victims are women. And this is a case type that I deal with very often. It is a federal felony to strangle or suffocate an intimate partner, dating partner, or spouse. And I am regularly prosecuting either in Kayenta or as a major crimes unit attorney strangulation cases, which is one of the most terrifying things that a woman can experience. And I am using women specifically there because it is largely women who are being strangled by largely men. Part 2, questions to the delegates. I would ask you to consider these questions. Is a brother or sister a family member? For any of you delegates on the line, I would ask you if your brother or sister, if you have one, is a family member. Is your child a family member? Is your current in-law a family member? That is not according to the definition of the Violence Against Family Act, family member definition. This is a problem I run into frequently. Brother punches his sister repeatedly in the face, and she's not clearly a family member under the family member definition under 535D of Title 17. Additionally, one's own child is not a family member, but their stepchild is. So there is some serious flaws in that statute because, you know, Delegate Karate, let's say, I don't know if you have a sister, but let's say she was married to someone. He is not your family member, but once your sister hypothetically gets divorced, then he can be welcomed to the family and is a family member under the Violence Against Family Act definition. This is a very intense limitation because I do deal with a lot of sibling crimes, sibling on sibling violence, especially in Kayenta. And it's heinous that your own child cannot be considered a family member clearly. I shouldn't have to resort to proving you're a household member or that you have a continued personal relationship. So we are overhauling the family member definition so that it is not a jumbled paragraph of semicolons and commas, but it is clear and definite. And we are also expanding it to include foster children and foster parents as family members. The current definition leaves out siblings, one's own child, and includes former in-laws, but not current in-laws, as I said. This means that a brother who batters his sister and her husband generally may not be charged with battery of a family member. I've actually had that exact issue pop up before, where I'm not clearly able to charge a VAFA offense. And I generally prefer to charge VAFA offenses because somebody who's convicted of a VAFA offense becomes a prohibited possessor of firearms. This next section might be a little unpleasant. It is meant to demonstrate some of the concerns that we have about the sex crimes involving children. Part 3, questions to the delegates. Is it illegal under Navajo law for a high school teacher or coach to text using their phone to encourage a 16-year-old high school student to have consensual sex with them? Yes, it is. That's a violation of 444, luring a minor by electronic communication device. Is it illegal under Navajo law for a high school teacher / coach to show pornography to a 16-year-old high school student? The answer is yes. 438, furnishing sexual materials to minors. Is it illegal under Navajo law for a high school teacher / coach to record themselves having sex with a 16-year-old high school student with whom they are having consensual sex? The answer is yes. That would be possession of child pornography. And then the final question I have for you, and one that I would like you to consider. Is it illegal under Navajo law for a high school teacher / coach to have consensual sex with a 16-year-old high school student? It is not. And that's because 442, which is inappropriately called seduction, only covers children under 16 and 17 years old. So you have to be 15 or younger. And 441 has an affirmative defense for children who are 16 or 17 that makes the effective age of consent on the Navajo Nation 16. You can compare that to Arizona's 18, Utah's 18, New Mexico's 16, and the United States is 16. So I think the plan there, the goal there, is to standardize it so it makes sense, because somebody is a child in one sense, but not a child when you record yourself having sex with them, in which case you have possession of child pornography, but the sex itself is not actually illegal. There is still what's called a close in age exemption, so that people who are within 3 years of age of each other, as long as both of them are at least 16 years of age, would be exempt from that. But a 50-year-old man having sex with a 16-year-old high school junior would be considered illegal. Part 4. This is part of the quality of life fixes. So, of course, the Reduction Council initiative occurred nearly 15 years ago. Like with many other areas of the Navajo Code, and this is one that I hope gets updated, the outdated committee names are still present in some areas of Title 17. I'd also note that they are still present in the Ethics Code and other areas of the law, and that it might be prudent to update those, because we do not have a Government Services Committee any longer. So in Title 17, we do have an instance of Government Services Committee. We see Public Safety Committee a couple times. We see the Judiciary Committee, and we see Resources Committee. That occurs with the wildlife offenses. Of course, respectively, those are called the Napkietia Committee, the Law and Order Committee, the Law and Order Committee, and the Resources and Development Committee. Other key fixes include fixing grammatical errors that are currently written into the law, awkward phrasing, and at times unintelligible phrases. One such phrase is in the most recent version of SORNA, which says the following statement. It says, a sex offender comes to can register. You heard that correct. A sex offender comes to can register. And I don't know what that means, frankly. It's an unintelligible phrase. So the quality of life fixes. These fixes address typos, outdated statutory cross-references. For example, 7 NNC Section 607 governs extraditions. And there's a cross-reference to 7 NNC 607 in 17 NNC Section 332. That's the provision dealing with essentially stealing cars. And the cross-reference is meant to say that, hey, car dealership, if you try to come onto the Navajo Nation and repossess someone's car yourself without going through the court system, that would violate this crime and you would be guilty of that. But that cross reference hasn't existed for almost 20 years. And other ones include the curfew statutes at 532. The ABBA eliminated the statute that is still cross referenced in 532. It was 9 NNC section 1320. That does not exist anymore. And then, of course, here's a clear written explanation of the DUI instance. So it genuinely says this in the statute. And every time the court in Chienta reads it, it feels extremely awkward because the question is, well, which is it? Is it 30 days in jail or is it 90 days in jail? Under the Navajo fundamental law principle of laws need to be clear so that people understand them, I'm not going to attempt to pronounce the Navajo version of that. We generally lean towards 30 days in jail because that's the only through line. So these are contradictions that have existed for decades in the statutes. Other fixes including capitalizing letters, adding definite articles such as the where they're needed, and replacing non-words with words. For example, the Human Trafficking Act has the non-word threatening, and that is not threading. It's used rather than the correct threatening. And that's genuinely in the statute. That non-existent word is genuinely in the human trafficking statute. Here are the more significant changes, and I'm going to talk about these a little bit longer. Negligent homicide. Our plan is to change criminal homicide, which is 17 NNC section 303, which currently lists 4 mental states. In criminal law, there are 4 possible mental states. There's intentional, which means that it was your conscious design to do something. There's knowingly, which means that you knew that it was a practically certain result to flow from your conduct. There's reckless, which says that you were aware and consciously disregarded a substantial risk. And then negligent, which is you should have been aware of a substantial risk. All 4 of those mental states are currently in criminal homicide. But in our efforts to ratchet up the sentencing for murder, which is what we want to name 303, we want to change it from criminal homicide to murder. We currently already have a manslaughter statute. That's 303.01. And we are hoping to keep that as it exists with a few quality of life fixes, because manslaughter deals with reckless states of mind. And negligent homicide, which would be a new offense, would deal with negligent homicides. For example, I used to live in the state of Rhode Island. In 2003, due to severe errors in how a nightclub was structured, for example, the fire door opened inward rather than outward. When a band's pyrotechnic display caught on fire, over 100 people died of smoke inhalation because they were crammed into the fire escape and they could not open the door because of the sheer volume of pressure of people. That was the Station nightclub incident. And I believe the owner of that nightclub was charged in Rhode Island with 100 counts of negligent homicide. So that is a situation where negligent homicide would be appropriate. Strangulation or suffocation. I'm going to talk about this a bit longer. Again, strangulation is one of the most terrifying things that a woman can experience. Yes, there are other incidents that can happen. We have a case that occurred numerous years ago in Chienta district where a brother strangled his younger brother by throwing him against the wall, lifting him up and strangling him. But largely, the strangulations that we see, and that is a federal felony under federal law, for which Indians who violate that in Indian country can be federally convicted and sentenced up to 10 years in federal prison. The vast majority of those victims are significant others. They are wives, girlfriends, intimate partners, people who have children in common. And somebody can pass out from having pressure applied to their neck within about 3 to 6 seconds, and they can die within about 2 minutes, depending on it. And strangulation really is a way of a man, and again, that's an intentional noun there. It's really a way for a man to show that he can kill a woman whenever he wants. That if you try to do anything, I can kill you with my bare hands. I don't even need anything else. I can literally hold your life in my hands, and I can end it whenever I feel like. It is a method to terrify women. And it is I cannot cannot emphasize how serious it is. And we really need a strangulation or suffocation statute. We've even had female police officers in Buchanan District strangled violently by suspects. And these stranglers are so intent on strangling women that they will ignore the fact that other police officers are there and are attacking them with batons to get them to release their chokehold from the officer. It is a severe offense. It is what I am more scared of someone who strangles someone than I am of most other criminals because there is a very clear link between those people non-lethally strangling women and eventually murdering women and police officers. So we are very much in need of a strangulation or suffocation offense. And as proposed, that strangulation or suffocation offense will have mandatory jail sentences. It'll be a minimum of 180 days. But if you strangle or suffocate an intimate partner, it'll be 365 days. You can't get out of that. It'll be mandatory fines with a strong presumption against converting those fines into community service work because these are extremely dangerous people. I would submit that most stranglers are likely psychopaths clinically. And there will be enhanced sentences if you strangle a peace officer, and there will be enhanced sentences if you strangle a minor. And if you strangle a minor under the age of 12, you mandatory get, under this proposal, 365 days jail and a $5,000 fine with a strong presumption against converting it into a fine. Resisting or obstructing a peace officer. We really could use this because we have people making officers' lives more difficult who are interfering with arrests, but not in ways that amount to, say, rescue from lawful custody, which is 372, or obstruction of justice, which is 370. But I submit to you that an officer is in danger when somebody passively resists them as they are trying to get them into the car. Say an officer is on the side of a highway and they are dealing with a suspect who is quite large, and that suspect goes limp. That officer could inadvertently fall into the highway and be struck by a car. So having some sort of penalty for that for people who block officers from engaging in their lawful duties is appropriate. And I believe the sentence that we're proposing is 14 days. So it's not the equivalent of, say, assault upon a peace officer, but it is to recognize that Navajo police officers lawfully enact the authority of the Navajo people. Again, I mentioned this earlier, animal cruelty 383. That'll deal with persons who essentially allow their animals to starve to death. And that'll deal with people who engage in other less egregious forms of animal cruelty. And of course, there'll be extreme animal cruelty. And there are very clear exceptions written into this proposed statute that govern anything that's a traditional and widely accepted Navajo butchering practice would be exempt from it. But, for example, if you put a grenade into a sheep's mouth to blow it up, that would generally be considered animal cruelty. And I would submit as a non-Navajo that that would not be a generally accepted standard of sheep butchering practices. So people who brutally kill animals would be subject to this. And of course, it would not just be livestock. It could be people who beat dogs to death or beat pets to death. We do not have a possession of drug paraphernalia statute. So when people are arrested with meth pipes, we cannot charge them with that. However, if they do have meth, we run into the issue of the fact that the Navajo Nation does not have its own drug testing lab. So we have to hope that the BIA drug testing team will do it. We have to hope that we can get the states to do it for us. But then I run into the issue of, are they going to come testify? So this would be a really helpful statute for when officers collect a lot of drug paraphernalia. This is actually proposed, the idea of this was proposed by the Navajo Police Department. Voyeurism, this would be a new sex offense. If somebody sets up a camera in your bedroom to watch you undress, to watch you be naked, or to spy on you when you have sexual relations with someone else, there is no crime under Navajo law that I can charge. Clearly, that covers that. I have had a case that qualifies as voyeurism, but I was unable to charge because there was no sex offense or other offense that I thought would work. So that's the person who sets up a camera in a locker room. That's the person who sets up a camera in the family bathroom to spy on uh, their stepson while he changes. There is no sex crime that currently reaches that, and that's what voyeurism is. Attempted aggravated sexual assault. We were originally planning to have 441B be a new sex offense that would deal with when somebody during consensual sex removes a condom without the consent of their partner, which is recognized as a sex offense in other states. But after working with the team that we had, we decided to carve out aggravated sexual assault and have a second version of it that will deal with when somebody attempts to aggravatedly sexually assault someone but does not successfully, say, penetrate them or actually successfully have contact with them. This is a statute that, again, deals with the sacredness of our children. You can read the child support statute, and it says that children are the Navajo's most precious resource. You can go to 1 NNC's 204E, which is the customary law of the Fundamental Law Act. That's customary law section. Dine de Ne'ev, it's Adebe, it's Ani. And it says that children have an absolute right to be free from all forms of abuse. And our submission here is that when somebody fails to pay child support maliciously or just intentionally, then they are abusing a Navajo child. We do currently have a statute that we could use. It's called persistent non-support. It is a very poorly written statute. It essentially says that they have to intentionally and persistently fail to provide food, clothing, shelter, financial support. But the issue there is that there is no legal definition of persistently. So how long does that even mean? This statute would say that if you go 120 consecutive days without making a single payment for your child support, then you would be guilty of this offense and you would go to jail for 30 days. That would be an unwaivable jail sentence. You would have to go to jail for 30 days. The statute as proposed says that there will be no fines. There shall never be fines because, of course, your money should be going to your child. So we think this would be a very good statute. The statute has numerous exemptions. So if someone is in jail, then while they still have a civil responsibility to pay child support, even if you're in jail, more criminal penalties would not accrue if you are in jail. So the criminal aspect of this would only really apply when you are out and about and you are failing to make payments, when you know that you are obligated to make payments. And you can talk to the chief prosecutor after I have to step off, and he will tell you that the Child Support Office has asked us to prosecute some of these offenders who are refusing blatantly to pay for the children that they created. And again, a Navajo is a Navajo before they're even born. That's the Fundamental Law Act. Again, I believe that's at 201 or 202. Criminal failure to report suspected child abuse or neglect. This is one that we, I think, largely were inspired from Delegate Crotty, because there are concerns about what happens when people who should be reporting suspected child abuse or neglect do not report it. What do we do? Well, there is a federal criminal statute for those who fail to report suspected child abuse or neglect of children in Indian country. I have attended a training on that, and from the trainer's point of view, there was only one instance of that ever being charged in the history of that statute existing, and that misdemeanor conviction was overturned on appeal. There are, of course, concerns that delegates have frequently raised. I don't even think I can point to a single one because I think it's a very ubiquitous concern about people who are threatening to shoot up schools. While we do have statutes that do govern this, such as 310 threatening, as well as false reporting, which is 485, this would be a much clearer set of statutes. And there's actually 3 of them. And these would be called terroristic threats. We call them the terroristic threat series. First one would be terroristic threats against an educational facility. An educational facility is very broadly defined. Medical facility, it includes everything from spaces where traditional healer practices to hospitals to chiropractic facilities. And then, of course, governmental facilities. That would include everything from state offices on the Navajo Nation to prosecutors' offices. Our office has been threatened, actually. Somebody did try to burn down our office here in Kayenta before. So we are not immune from being the victims of people threatening to kill us. One very annoying thing about the Violence Against Family Act is that we have these statutes. We have aggravated assault of a family member, we have battery of a family member, and we have aggravated battery against a family member. But, if I was in the room and threw a cup at, let's say, Delegate Crowdy, I hope you don't mind me using as a hypothetical, but if you were I'm not going to say sister, but if you were my cousin and I threw my phone at you and I missed, that would generally be considered to be an assault, an attempted battery. But my phone is not a deadly weapon. So I can't charge aggravated assault of a family member. So we are hoping to add an assault of a family member because there have been numerous cases where I have wanted that exact statute. And the fact that we don't have it makes no sense. When the council in CN 5214 added the peace officer victim series, they had assault upon a peace officer, aggravated assault upon a peace officer, battery upon a peace officer, aggravated battery upon a peace officer. When the council enacted the VAFA, they left out assault of a family member. And then these are the new VAFA offenses as well. Extreme animal cruelty involving family violence, which would be the new 560. And then the final one would be coercion of a family member through threats of harm to pets or livestock. And then I'm going to proceed to some of the new sections, and then I will have to depart. I have sentencing hearings across the street momentarily. So I really want to emphasize this. Several offenses will have mandatory jail sentences that do not currently have mandatory jail sentences. The Navajo Nation could enact what's called enhanced sentencing authority under the Tribal Law and Order Act. Some tribes that have done that, I believe, include the Choctaw Nation of Oklahoma and the Salt River Pima Indian community. Those tribes could sentence people for certain offenses up to 3 years. The maximum sentence I can achieve for somebody who brutally murders, let's say their mother, which is a case I did have in Kayenta, is 1 year in jail. And, that definitely, in our view, shows that under the current jurisdictional scheme, Navajo lives are essentially less valuable than non-Indian lives off the reservation because of how measly that sentence can be. So we are hoping to mandate mandatory 1 year in jail, mandatory $5,000 fine for murder. If you murder someone, we generally are of the view, the prosecutor's office is, I know my friends in the public defender's office might disagree. We are generally of the view that you should have to pay a fine for that. You should have to pay what sentence we can get. If you murder someone, you should have to go get a job for that if you're not being federally prosecuted, which hopefully a lot of these people would be, but they are not. There would be mandatory jail 30 days minimum for criminal failure to pay child or spousal support. If you have a child, again, Navajo children are our most precious resource, and you are failing to financially support that child, that obligation is on you. There are only 2 existing offenses that will see increased penalties. There are no other offenses that will see increased penalties. Again, I'm distinguishing that from offenses that will have mandatory jail sentences, but those are consistent with the maximum jail already available for that offense. Here are the 2 offenses. Again, sexual assault of a minor, 442, which we are renaming from seduction. Again, that is a heinous name to call raping a Navajo child. I am disgusted by that every day that I have to say that. The first time you rape a Navajo child, you can get 6 months for that. We want that to be 1 year. The federal maximum for raping a child is life in prison. And in certain child rape cases, including those where the child dies, you can be sentenced to death federally. The current maximum sentence for bootlegging is 1 year. The current maximum for sexually abusing a Navajo child is 6 months. Again, I think I understand that bootlegging is a problem. If there is anybody in the room who thinks I don't think that's a problem in the Navajo Nation, they would be incorrect. But I would submit that raping Navajo children is more of a harm than bootlegging. Second, fines will be introduced as a punishment for those sex offenders who fail to register as sex offenders or who abscond from registration. The only possible sentence currently for 2112, which is the absconding or failure to register, is jail. We would like it to be a minimum $100 fine, maximum $5,000 fine. Those persons uniquely have already been subjected to due process. They have already been legally convicted. And so, by definition, they've already been convicted of a crime. And then I'm going to end with this. I will again emphasize the rape shield rule. somebody should not be able to attack a victim as being, quite frankly, a slut in court. That should not be able to happen. There are very limited circumstances where you can bring in their prior sexual behavior. For example, a woman who tends to have sex with different partners, that's not a crime. It is not a crime to be a woman who has sex with multiple partners. And to bring that up to imply that she must have wanted it in a rape case is incorrect. It's a violation of her dignity as a person. We are hoping to allow us to charge all three types of homicide and argue that each of them could work. That will be 303.03. We're going to be updating the rape definition again. I want to emphasize that Delegate Crotty did sponsor a fix to the rape definition in 2023, which added affirmative consent, which is the concept that the absence of a no doesn't mean a yes. We are hoping to expand that further to clarify that there is no spousal exemption for rape. There used to be in states a legal doctrine that it was not you were not capable of raping your spouse. Some tribes still have those exemptions. I'm not going to name them, but some tribes do say that your spouse is unrapeable. We want to explicitly disclaim that under Navajo law, that you are not incapable of raping your spouse. We also want to emphasize that regardless of whether a victim gets drunk on her own and then is raped thereafter, or whether somebody slips a drug into her drink and then she is raped thereafter, both of those count for intoxication. Some jurisdictions say that the woman who gets drunk on her own and then is raped is not a rape victim, while they say that only if she was drugged is that a rape. That should not be the case. We are also asking for mandatory arrest warrants upon request for SORNA violations. You can talk to any of the SORNA officers and they will tell you that sex offender violators who are charged with 2112 will generally not answer criminal summons. So we would like a statutory authority to automatically get arrest warrants. Again, you can only be charged with 2112 if you have already been convicted of a sex offense. So you already have a level of due process built into before I charge you with that. We are hoping to have mandatory absolute rights to domestic abuse protection orders for victims of VAPA offenses and strangulation or suffocation. So that means that if you are the victim of somebody convicted of that, then you have an absolute right to a domestic abuse protection order. You don't have to go through a hearing. You just have to present a copy of the conviction and say, I would like a protection order. And if the district court does not issue that protection order, then we're asking that the statutes say that the Supreme Court has to summarily reverse it without hearing. We are hoping to be able to more clearly domesticate state search warrants because there are some instances I've dealt with this where somebody murdered another Navajo in Flagstaff. He's since been convicted, and then he fled in his car, which had DNA evidence in it, to Lower Greasewood. And what we did was we helped domesticate the state search warrant in the Dilcon District Court, and we would like clear statutory authority to do that because some police departments have no reason to be cross-commissioned with the Navajo police. The Phoenix Police Department has no reason to be cross-commissioned. But if a Navajo flees with evidence of crimes to the Navajo Nation, the state, with our involvement, with our domestication of their search warrant, should be able to search them. Navajos should not be able to flee to the res to escape accountability. And that's, of course, what extraditions are, too. We're clarifying the applicability of that, of the extradition and federal detainer statutes, including fleeing from sentencing. So that's where I'm going to have to end, and I'm going to have to hop off so that I can go deal with some sentencings. I thank you for your time. I appreciate you listening to us. This is a very, very serious issue. We're not purporting to fix everything in Title 17 with this legislation, but we need to fix a lot of the critical errors and deal with a lot of the immediate needs for fixes. We need to eliminate the statute of limitations for raping Navajo children. We need to eliminate the statute of limitations for murder. And I thank you for your time, and I will exit if I can.
Thank you, Kevin. Now, I'm going to turn it over real quickly to Jamie. Jamie, do you want to just say a few words before we move on real quickly? Mr. Henio?
Thank you, Chief, and everybody that's on the line this morning. Good morning, Yatre. And what Kevin had covered this morning, there's is pretty much, I guess you could say, the beginning of how we want to see Title 17 moving forward and enhancing the law and order code on the Navajo Nation. At the same time, we do have the participation of the Navajo Public Defender's Office, who are also looking for, I guess you could say, equality and justice for both parties, and for the defendants and also for the plaintiffs. And therefore, we've been working together, and there have been several instances from my observation where there was a proposed amendment, but then again, there was always that veto capability of the public defenders. And so we came back and sat down, talked about it some more, and then came to common ground. That's how we should move forward with the this particular amendment, and it's a work in progress. And I believe that involving the public defender's office helped us a great deal to where we're at right now. And as we move forward with this legislation, there will be more, I believe, added, because there'll be, from my experience as a council delegate, once the legislation is being put to the floor, it belongs to the council. And ADA don't make their own amendments as far as what they see that they needs to be added to. So we're open to that discussion also too from the Title 17 Review Committee. And so we look forward to providing I guess you could say, presentation to the council committees and also Nabikiati and also Navajo Nation Council, and ultimately looking forward to having this legislation passed and then presented to President Nygren for his review and approval. That's all I have to add, Chief.
Mr. Hanyo, really appreciate it. For those how many people do we have now on Zoom?
We have 37 participants.
37. Okay, we started with 20, so we're up to 37, almost 40, which is a good turnout. This is Vernon Jackson, the chief prosecutor for the Navajo Nation. Jamie Henyo is the prosecutor, senior prosecutor in Rama, who just now spoke, and before that, that was Kevin Barnett, who's is an attorney prosecutor in Kayenta, and also the lead for the major crime unit. So we're at the end here of our presentation, and we would like to open up for any questions that you may have, or if you have other business to take care of, we can reschedule and come back again for additional questions if there's any. Right now, though, we don't want to go too deep into the provisions itself, but if there's any general questions, that might be good. So I'll turn it over to you, Madam Chair.
Okay, thank you. I appreciate it.
Hello. Hello.
Yes. I'm sorry.
This is Kathleen.
On mute, please. And so we have a protocol here with our task force. So if you want to speak, please use the functions on the Zoom, or you can text staff. Thank you. We're going to be very strict for this call since we have individuals here who want to ask questions. Thank you. So I wanted to say, I'm sorry, you're going to have to go on mute unless you've been recognized for the record.
Okay, Ms. Crotty. Ms. Crotty, this is Kathleen Bowman. I would like to make a statement, please.
Okay, Shama, but I want to just make sure that you understand that we have a protocol here with the task force, and but we will defer to your comment out of respect as Chief Public Defender. You have the floor.
Thank you, Ms. Crotty. I have been the director of the Navajo Public Defender Office going now on 32 years, and I can see both sides, and I have never had objections to amending the statute of limitations for sexual offenses and homicides. Never. I have never had, and I figured 2-3 years is not enough for statute of limitations for those categories. But I would just like to say that all of these amendments that are being made right now that were talked about by Mr. Barnett, I have never had an opportunity to sit down and discuss every one of those amendments that he's talking about. I know some of them we did talk about when we were going through Title 17, but some of the amendments that he's talking about, we never discussed those. And in my practice, I can see both sides. I also sympathize with victims, and I myself do not like to see our relatives battered and mistreated. But I can also see the side of the defendants where they're entitled to due process and they have rights. And so that's why my concern is these changes that are being proposed, some of them need to be discussed because committee members, I'm sure not all have a background in criminal law or litigation and may need to see the whole picture, not just one-sided. And just like the comparison between the number of years for, I think it was a sex offense against a minor in the federal context and compared to the tribal context, we have to keep in mind that our jurisdiction is limited, and it's limited by the feds, and it's covered by the Indian Civil Rights Act. Now, the feds also have concurrent jurisdiction. So a sexual offense against a child can also be prosecuted by the U.S. attorneys. And yes, those people will be looking at a lengthy time in prison. I believe life sentence was what was mentioned. So there is a difference, and that jurisdiction is there all the time. They can prosecute anytime they think that someone needs to be prosecuted in the federal system, and they would be looking at a lot longer time. So if we have someone who's very dangerous, which I've heard, they can be federally prosecuted and sent to federal prison somewhere. They don't have to be living among us, but it's up to us to sit down with the U.S. attorneys and the feds, maybe even Kash Patel, who is the head of, I believe, an official in D.C., who is in a position to make sure that those crimes are prosecuted in the federal system. So our jurisdiction, we can't change unless the Indian Civil Rights Act gets amended, or if we adopt some other federal laws, which we have not adopted, and then we can enhance our sentencing. But I'm also concerned about our lack of resources. We don't have enough detention officers, police officers, defenders, judges, prosecutors. And we're talking about mandatory jail. Who is going to take care of those people and take them back and forth to their hearings, because not all of our jails are open. And heaven knows we don't even have enough resources to be feeding them. That's what I understand. And then it's going to take detention officers driving them back and forth to their hearings. And we did have an accident one time, and defendant lost the use of their legs or lost their legs. And those kinds of things happen because of the lack of resources. And if you say mandatory jail, mandatory sentencing, we have no employment opportunities here for our people. Where are they going to work to make up for their fines or child support or whatever? We have not developed economic enterprises and businesses so that people can be employed. So those are things that we also have to consider when we're trying to change these statutes. We need to look at the real world that we live in. Anyway, thank you, Ms. Crotty. That's my statement.
Okay, thank you, Shema. I appreciate that. And we recognize that this is a high-level summary. And our goal here is we're the Missing and Murdered Danette Task Force. On this call, the Navajo Public Defender's Office does have a representative, and so does the Office of the Prosecutor. And so what we're doing here is having a conversation for the task force, but I appreciate your insight on how to move forward. We're going to continue to address resources. One of our priorities, per our report to council that was approved, is working collectively on a public safety fund. And so we could expand that not just to criminal public safety, but you're under DOJ is the Office of the Prosecutor, the public defenders under the Office of the President and Vice President. So what resources will you need in the next 5, 10, 25 years to implement these amendments and changes? I don't believe that we should make any amendments and not fund, because that then creates this system. I do know that we have Dr. Gray Eyes on the line who's with detention. But what we'll do is give the opportunity if the programs want to come back and present their recommendations or how to move forward in light of some of the challenges that the Office of the Prosecutor raised. I always believe in communication and collaboration. So we could use this space in the task force. We're not a committee or a subcommittee. We're like an action. Every week we're meeting to move things here on Navajo Nation. And so I do want to recognize we have Acting Division Director Henderson with Public Safety on the line. We have Malcolm, who's with the head of criminal investigators on the line. And so we do collectively bring all of the individuals who need to be at the table for these discussions. So I want to just thank you and your team, Mr. Henyo Shiash, Mr. Ken, my cousin over there. So we're putting him to work. And so I just wanted to we'll open it up. Shama, did you have some questions or observations? We do have Delegate Helena Nesbagay here as task force, and in person is Miss Janet Deschini. So we'll go to in person first, and then we'll see if anybody on the line has a question. Please use the Zoom emojis or text staff, and I'll recognize you. Thank you. Shama.
Oh, yeah, Nana Shawet, and thank you to the presenter. It was very informative of what I've seen and heard here this morning. And I know as a nation, our laws are very weak. You know, that's probably why we're coming together to strengthen our weakness. So this is a start for all of us. And our goal is to work together to strengthen our laws to better for our families, for our relatives, mainly for our youth that can't really voice what they go through out there. So, and I really appreciate each and every one of you for coming together to always show your support and to help us and assist us in this way. And I thank each and every one of you here.
Thank you, I appreciate it. So Ms. Deschini do you have a statement or a question?
Maybe a statement, yeah. Yate, this is Janet, this cheeky. I don't know why I'm like crying, but I'm just happy to hear that this whole process is starting. As a survivor of childhood sexual assault and regular adult sexual assault. And like everything, I am glad this is happening. And I want to speak up for the victims and the families of MMDR issues everywhere. That I'm happy as I was listening to the US Attorney talk about all these laws that he's recommending. I really, really want everybody who's on call, who's here, to listen and to really make sure that you are able to increase within the capacity of the Navajo Nation to really bring that forward, because we are suffering. I am almost 50 and I have had this trauma since forever, if you can understand, and it hurts. And these are things I have, and you guys know what trauma does to you. You know how it works through you. And for those of us, when I've had events, people call me and they tell me, this is what my daughter's going through. This is what happens when she smells the smell. This is what happens when she sees someone similar to him. And that is true trauma that is working it's not just two of us. There's a lot, right? You guys know the statistics. It is between probably at least reported, right? It's 1 in 3. I believe it is way more than that because reporting is different from keeping it silent. And for so long, we have been silent. But if you guys all here on this call and in this meeting can work together to increase that so we don't have to have our children go through what we went through. One day I hope that it'll happen, that nobody goes through what we went through. But that will only determine from the work that we've established here. So that's all I have to say. Yeah.
Appreciate that, Shadeja, for speaking for so many of our survivors who've been silent. And I just want to recognize too that this has been a long-term project. 2018, I know we tried to do a whole overhaul of Title 17, and what we learned was we had to take it step by step, bring everybody into the conversation. But that's also 7 years of not having the laws that we need on the books. So and what I'm doing is using the task force and our recommendations and my role as chair to work with the chief prosecutor and anybody involved to say, we need those laws to implement. I'm not gonna wait any longer. I actually wanted to do emergency legislation. And so, but out of respect for everyone, we're waiting, and that's why we're here, and we hope that we can at least get this started. And I wanted, Chief Prosecutor, I wanted to recognize his team. That individual is actually not a US attorney, that he's starting up, he's here, and this is one of the things that we help support the office of the prosecutor is create a major crime scene. So they have been struggling for years, severely underfunded. And it wasn't until, I don't know, maybe 8 years ago when we started all this. So it is a funding need, and that's why we want to create that fund. So in the future, this office is never forgotten, or the offices that are critical, so that we can maintain this type of accountability. Like we look at, it's mandatory funding. We ask the feds for mandatory funding, so we're gonna ask Navajo Nation for mandatory funding, and collectively we'll see what that need is. I want to move away from annual supplementals to giving you a base budget. Not only this program, but everybody who's involved in this, a base budget so that you can meet the needs of the people. And another conversation we're gonna have to have is with the courts. And we're looking at the challenges there with the courts. And so what is also their need to get these prosecutions happen. And we did talk about the need for Navajo Nation. It's in 2010, and we have the subject matter experts here, you know, the Tribal Law and Order Act was passed. Navajo Nation declined to incorporate those federal laws that could enhance our system. So that's 15 years of not building up a system we need. And we hope with this task force that we continue to provide Navajo Nation leadership with those recommendations on what's best for Navajo to incorporate so that we can meet the needs of our people. And I'm also trying to be open to the other side of the offenders, because they also need those resources where we have no place for the sexual assault offenders to attend those monitoring afterwards. I think I ran into them pre-COVID at the Quality Inn, but we also need to talk to the courts so that they do not allow name changes for these offenders, so that they can evade being, being accountable. And so when the courts are openly changing names, that's gonna be my ask to Chief Prosecutor, if we could see in that language that they cannot change names. And matter of fact, we have the council has already prohibited non-Navajo Tier 3 offenders. I know the number of Navajo Tier 3 offenders right now are over like 530. And so if they are not complying, they have no, I think, this is my opinion, they have no space here. They have lost that right to be here. And so I'd like to dig into that conversation a little bit more, because in some of our community-based work, we do have advocates who regularly check the website and want to make sure that they're, these individuals are complying, that they're not going to places like schools or other places that they're prohibited. And then what happens when they attempt to go to these spaces? So I know that'd be an interesting conversation, and I would want the public defender to be part of that, but it is my understanding that so far for Navajo Nation, we haven't convicted someone under those statutes, so that's a federal conversation, but you're our branch to the US Attorney's Office. And my hope now with the new administration is that they continue to focus on violence in Indian country. I know they put a lot of their attention on the immigration issue, and we've also asked the head of FBI to continue to address violence in Indian country. And so Speaker Curley met with him in DC about 3 weeks ago. But what we would like is always craft the position of Navajo Nation. And at any time, we're all pushing the same recommendations, the same funding, because it is a holistic. And we do want to do the prevention part. And that's where Janet helps us. Her lifetime passion is prevention. And so, so I just wanted to say that's where we're at as a committee, and I appreciate that you invited us here to your conference room. And I think this could be an appropriate place for us to continue to meet if your schedule permits, because a majority of the task force members do call in, and that allows us for maximum participation.
Absolutely.
Okay, appreciate that.
Yes.
Okay, so that was a lot of commentary, but follow up on the SORNA issues.
Sure.
Want to do a time check? We're at 9:51. So beyond Regina, is there anyone else with the call?
Yes, so yeah, going down the list, the first one's going to be Salanta Jim, the deputy director for DCF.
Oh, she's here as a community member.
Okay, as community member, and then we have Vanjie Shorty, who's gonna go after Salanta, and then after Salanta, or yeah, after Vanjie, it's going to be Regina.
Okay, so let's move forward. Shade, Salata, you have the floor, and Salata, in her role here at the task force, is as a community representative, and she's a surviving family member. Salata, you have the floor. Shade.
Thank you, Delegate Crotty, and thank you to the prosecutor's office for your presentation and the time on the agenda. And again, I am here representing the task force as a community representative and advocate. I have 3 comments I want to share, Delegate Crotty, for the record as a task force member. One, I am concerned about the lack of coordination between the public defender's office and the prosecutor's office regarding Title 17. I really feel that as a task force, we need to make the 2 entities come together, because it comes back in the end hurting our people when the 2 offices are not coordinating together. We see families and victims not getting the answers they need when we don't have the public defender and the prosecutor's office working together. And I've seen it on several levels. So as a task force, I'm hoping we can really get them to come together on Title 17 as soon as possible, so it doesn't impact our communities and families. Secondly, I feel that we need to have the latest copy of the Title 17 law. I think there's many versions that are floating around out there. And as a community representative, it would be good to have the current and most recent copy that is law, not the amendments, because we have those copies, but or the proposed amendments. but the current law that our people are now under and how we can study that and make sure, we are able to um, articulate that back to the people. The third thing I want to share is there was a lot of good information shared in the presentation, and we do get a lot of families and victims in the communities asking questions to us, and we need to have that public education and that public awareness provided by the prosecutor's office on Title 17 to the community in layman's terms and in the Navajo language, because many of our people are still trying to understand their rights. And I know this is tied to the Victims' Rights Act. We need more public education, and however we can help as a task force and as advocates, we would like to help. Thank you.
Appreciate that. Shaz, would that be possible that you could share the current version of Title 17? And I do want to say I recognize, and I'll talk to the Office of the Speaker under Navajo Nation law. The legislative office of the Legislative Council is supposed to keep our codes updated, and that has not happened since 2010. We just keep putting amendments or addendums. And I think that's what's creating some of these cross-reference, and it's important when we talk about the laws and updating from when the council was reduced. And, that could be the Office of Government Development, but someone is getting paid to do that work, and we need that to get done. Or else we'll move that funding from those offices to another entity to get it done. Okay,
Yes,
my comment, that's my comment.
we can provide the current Title 17 to this task force. We can do that, no problem whatsoever.
Okay, and then we'll push that out to staff. Staff will push that out to the task force. Appreciate it. Thank you for your comments. And we are having a violence prevention summit next week in Gallup. And so I think MMDR is under the Dine action plan. And so the co-chair is Acting Division Director Henderson, and in her role as Deputy Salatsa Jim is the co-chair. So we're also funding for this next fiscal year. I've requested $500,000. And so we'll come back to the DAP leadership to see how is that going to help the next year's cycle, and then what do programs need, or do we need a facilitator? Like, do we need someone? We do have one of our evaluators on the call. So the task force is also monitored. We want to make sure we're accountable to what how we have been created, and especially to the survivors and the family members. So I'm going to move forward to Vanji, and then Regina, you'll be next. So Vanji, you have the floor.
Okay. Hi, good morning. Vanji Randall Shorty here, mother of Zachariah Juwan Shorty, who was murdered. I just want to say, that I did enjoy, or I like the presentation. I like the changes that are made, and I want to thank you for that. And I want to also include that, with these new changes in the laws, we as families who are impacted of sexual assault, or having a loved one murdered, it's a lifetime sentence for us. The pain doesn't go away, just like one of the speakers mentioned earlier. It's a smell. I live here in Kirtland, and I can't avoid going places that Zach and I went to, and these memories flood. And when you make these changes in these laws, I ask you to keep those into consideration because I know that you're thinking about both the victims and, the defendant and, the opposing parties when making these changes. But we as victims, we live a lifetime sentence. And again, I thank you. I thank you for listening to me and taking this time.
Yes, thank you, Vanjie. I appreciate that. And with Zach's case, what we'll do is work with the Office of the Prosecutor. They have advocates who have presented. And since your case is federal, we just want to make sure that our federal partners are working with the Office of the Prosecutor so that they are aware and can monitor these cases, similar to what we do with our multidiscipline cases throughout Navajo Nation. And our hope is that the MMDR database can start tracking from a lot of these cases, and that will help us tell the true story of what's happening. Because in my experience, just relying on the federal system to prosecute or to detain is an injustice. And how they work with families, and we have families where their children have been murdered, and the individual gets a very light sentence. And so I agree with that lifetime of pain. And there could always be conversations about restorative justice in the future. But at times we still have to stay fierce to know that our families are suffering, and these individuals target our community members, especially our elders, because they're scared. And so we want to make sure that we stay firm with them. I appreciate that. And so I'm going to move on to Regina. Shade, you have the floor.
Good morning, everyone. My name is Regina Bigay Roanhorse. I work here at the U.S. Attorney's offices for Arizona, New Mexico, Utah, Colorado, and Nevada. I represent the U.S. Attorney's office when I come to these meetings, and the executive office of the U.S. Attorney's, which is out in Washington, D.C. I have a program manager that I report to. Her name is Deidre Onstad. I did want to let you know that I've been on the job since September, and I've been observing and watching and getting to know the U.S. Attorney's offices. And I can tell you that Arizona is very proactive, as well as New Mexico. So the last time that we sent a summary of charged cases to the Navajo Nation Prosecutor's Office was January 13th of this year, before U.S. Attorney Gary Ristano left the office for Arizona. He sent a direct email to Vernon Jackson, and he also gave instructions about who's going to take over in the criminal section for the office. And he basically stated that, we want to provide as much public information as we can. So ever since then, Kyoko Patterson, who is a federal prosecutor, a assistant U.S. attorney, she had some MDTs there in Navajo Nation. I went to them in February. One was in Chinle and one was in Window Rock. So I know Denise, thank you for meeting with me, and also the U.S. attorneys that came. So what she did was she brought federal prosecutors with her, 2 of them. And she asked, and she went through cases with the criminal investigators, and she went through cases with Kevin. And she asked, she said, are there any other cases you want us to look at? She had 3. She was one of 3 federal prosecutors asking for cases. So internally, everybody, especially here in Flagstaff office, we have 3 federal prosecutors who are not Native that do Indian country cases. My supervisor, Denitra, is working a case out of Navajo Nation and Hopi. So I'm just saying that there is a lot of activity. It's just that sometimes I can't tell everyone the specifics about different things, but I can tell you that if you need me to take messages back to the U.S. attorneys for the states, I will. I recently met with the new tribal liaison from Utah yesterday. His name is Samuel Peed, and it's Pead. He is very much willing to work with Navajo Nation and mentioned that they don't get very many cases. At the Utah Tribal Leaders presentation I did about a month ago, one of the advocates said, we don't have any Navajo Nation police presence in the Utah portion of the Navajo Nation. Why is that? That was a question for me. So I referred her back to the police department for Shiprock because the area she was talking about was in that police district. So we are very much committed to working with everyone. If you want me to directly talk with any of the federal prosecutors, that's my job. That's my job, and I will do it. I have been Navajo prosecutors in the 90s. I have a Navajo Nation bar license since 1991, so I fully understand what the discussion is here today, and I applaud the work of the prosecutor's office. In short, I just want you to know that I am a resource. If there's any person, any family that's not getting any answers or any feedback from any of the cases that have where federal jurisdiction exists, and that's very complicated to explain. If there's any cases, then I will be the person you should contact. I'll put my contact information in the chat, and then I will follow up with the FBI, off reservation law enforcement, and other places. And I also wanted to applaud the Navajo Nation for their work on the Tribal Community Response Plan. I can tell you that you guys, Navajo Nation, is far ahead of any other tribal nation in developing response. And I know you feel like it's not perfect. Nothing is, but I just want to congratulate you all as the MMDR task force. You have the basics and the information and the advocacy, and continue to do that work. So thank you so much.
I appreciate that, Regina, with the update. We'll follow up internally. What is if the Office of the Prosecutor needs additional support with the U.S. Attorney's Office? I do want to say, since we've been advocating the last 11 years, things have communication has improved, but it has to be consistent. And something for me as tribal leadership is not consistent is data. Because you have 3 U.S. Attorney's Office who track their cases differently and want to explain, where I just want to know what happened to the case. And so they're very, I'm not asking for specifics of the case, I'm just asking for accountability. And are they communicating with the Office of the Prosecutor? So it sounds like that happened in January. I'm not sure if that's as much as you need. I would say at least quarterly until we have all of these cases kind of caught up. And I know for the FBI, there has been conversations here with Navajo Nation with this surge. Elliot Neal reported back from the U.S. Attorney's Office that they're not going to notify what cases they're reviewing. I don't think, I mean, publicly maybe, but government to government, we should collectively know what cases they're reviewing so that we could keep them accountable. Because let me remind you, 2018, the head of FBI in Washington, D.C., on the record in the Senate, the U.S. Senate Indian Affairs, said there was he had enough agents out in Indian country and that missing relatives was not an issue, and walked out of the hearing before tribal leadership spoke. So we are rebuilding that trust with our federal partners and to keep them accountable. And Kyoko has been part of those conversations where previous task force, like the Sexual Assault Prevention Task Force, where we asked, what of these cases had they were first reported missing? And they also at that time had said they didn't feel that that was a data point that they should collect. And now we know that we're finding with families telling their stories that an individual is reported missing and then later is found with a crime. So yes, we've built to where we're at now. I still think there's room for improvement, and we're concerned about the federal funding streams because your position is not built in as a permanent position. So there's still a lot of advocacy that we need to do. And to sustain our advocate program here on Navajo Nation, how do we move forward? So those are all critical questions I always ask all of the U.S. Attorney's Office. And I think I'll pause there. Is there anything else you would want to say?
I'll just make it short and just say that there's been a lot of points raised today that it does need to be talked through and worked through. I am encouraged by the responses, the positive responses to our presentation here today about what we can do to make life better in Navajo communities. There's a lot to say about the relationship with the federal government, with the FBI, U.S. Attorney's Office. Since I've been here, there's been some improvement in areas of liaison and some communication. We are still having some difficulty with the federal investigative materials, but we're slowly getting better as we're moving on. As you can see, this office space here has helped us to gain the necessary resources, the infrastructure to ensure that we're capable of preserving all of the necessary federal investigative materials that were provided for prosecution. That's getting to a better place also. So there's a lot to talk about. And I'll just say this, and I am encouraged about this meeting, not necessarily to say specifically about Title 17 and improvements, but more about the conversation we're having here about some of the things that we can do to make things better in many different areas. So I'll just stop there for now. And I'd like to meet with you as we go forward to figure out next steps and figure out exactly what we're going to do after this session. So thank you very much for your time, Delegate Crotty.
Okay, appreciate it. We do have 2 more requests.
Yes, we have 2 more requests, one from Laurel Shepherd and the other one's gonna be from Andrea.
Okay, so Shanella, you have the floor. I just want to do a time check. It is 10:12. And so task force members this conversation doesn't stop here. It's going to be a continued partnership. You have the floor, Shanella.
Yeah, some of you might be familiar with me, but I'm a community representative that sits on the MMDR task force, but also I am the program director for Victim Services program that services the Arizona part of the Navajo Nation. And listening to this and being in this realm of work and working in Title 17 as well, it's been a long time. And so I'm going to speak on behalf of a lot of the victims that we are working with day in and day out. And so this feels like, as Amber mentioned earlier, it's been something that's been the tribe's been working at for a very long time. So my suggestion and part of the work that we're doing with the task force is also very data driven. I guess my first question before I do the suggestion is, what is the time frame for these amendments to go through before it goes to council? What does that look like?
I can.
Go ahead.
I was just going to say that that all really depends on the momentum of our conversations about the sponsors, and also how we will wrap the package up so that we can deliver it and hand it to you as to what the amendments are. Incidentally, these amendments that we're talking about did pass through DOJ, and so they have been reviewed at DOJ level also. So the answer to Ms. Shepherd's question is that this could happen pretty quick in terms of the discussion of what we do to get past the public defender's concern, and then also how that we actually deliver the package to you to say that this is it, these are the amendments. And then I think the best thing to do is just take it to the committees and let it land where it needs to land. As you know, that there's two different viewpoints of how things should go forward. But I'm hearing in interactions with the community, interactions with others, is that the Title 17 does need to be strengthened. This is our narrow approach. This is not a comprehensive approach to change everything in Title 7. It's very narrow, and it was very structured in a way that all the stakeholders realized that we were only doing those pieces that we felt like we needed to do. So that's my answer to the question. All right.
And then I could do an input. I already made a legislative request for an emergency legislation to be drafted to implement Title 17. That was conveyed with Office of the Prosecutor. So my request is if we could get the public defender to see the amendments.
Yes,
And
yes,
I'm like end of business day, like
Yes.
I'm at negative. So if we could just get that there, I'm here in Window Rock today, we could work with our team and get something going. Because
Absolutely.
there's, my concern is crimes committed up until this point, until that is passed,
right.
will not benefit. Like they will not
Absolutely.
benefit, and so we just need to get this done collectively.
Sooner rather than later.
Okay, so I
Right.
appreciate that,
Right.
Shamila. So that's our commitment on my side, and I'll keep the task force updated. And your comment?
So with that, I guess a recommendation, just based off of the history of how the updates and stuff have been completed with Title 17. So I'm looking at historically and how it's going to move forward. So and then also working with the data is my recommendation is, why don't we look at the data from law enforcement to see what the crime trend is, find the laws that are applicable to those laws that are plaguing our communities at the highest rates, and let's address those first, because that is the problem. And let's get those pieces, at least those pieces, passed individually, because that can be done faster than trying to pass the whole thing. And so let's use let's use the information that we already have. Let's grab EPI. Let's get the information for which crime is the highest. And in my area, what I'm seeing as far as victim services is a lot of sexual assault, child sexual assault, and so it goes in an order. But I think our decisions should be very data driven in how we move forward. And also when you work in program implementation, those are I feel like we're taking a giant piece and trying to fix it, when studies and statistics show that when you break up a large goal, the likelihood into pieces, the likelihood of you achieving it faster is higher. So that would be my recommendation. And this, again, the urgency for it, this is needed. Our families are going through, I just had 2 cases walk in the door, and they're not going to see or benefit from any of these changes. And so we have probably hundreds of calls for service for violence daily across the nation. And we need to get we need to do something. And it's really frustrating for families to try to say that this is the law and this is how it is. We can't do anything beyond this. And then I'll leave it at that. That was my recommendation for how maybe it might move faster for approval. And then the second portion is I strongly suggest that I'm thankful and grateful that everyone here has come to the table. This is one of the first times that we've had this many various departments that work in with families that endure violence and together at one time. So I think I just want to reiterate how important that is for the safety and our community health moving forward. When you have all your people working together to support families in a holistic manner whether it's from law enforcement to victim services to the prosecutor's office, everybody on board, the likelihood that your cases are going to go smoother, and then your families are going to leave your offices, our offices, just a little bit better, and equipped with the tools that they need to start that process of healing or enduring as well. So I'll leave it at that, Shanella.
Okay, appreciate it. Thank you. And so with this presentation, I'll continue to move forward with my legislative request for the amendments. I was focused on the statute of limitation, but it looks like the team has been able to incorporate some other aspects. So if you're ready, and Shama, if she's still on the line, I'll be at the council chamber. I know they're on reports now, and this is why sometimes delegates were late to other meetings, because we have to prioritize and have these conversations to improve, the laws and moving forward. So appreciate that. We'll move on to Andrea and Mr. Curley Shiaj. We're going to invite you to our Tuesday call so that we could have that discussion on the MOU. Andrea, you have the floor. Shut it.
This is Kathleen Bowman. Before you conclude, I would like to make another short statement. So I can wait until you give me the floor.
We'll do.
Thank
You'll
you.
be right after Andrea, Shama. So stay on the line, please.
Hagoshi.
Thank you, Yate. Thank you, Honorable Crotty and task force members and guests. My name is Andrea Bial, and I am a volunteer with Four Corners Canine Search and Rescue. We help a lot of MMIP families with searches and recoveries for their missing loved ones. And this is more of what we see in these cases with families. And it is a concern of ours too on behalf of the families. It was mentioned bootleggers have a mandatory, not mandatory, it carries a 1-year sentence. Many of these cases we work with, bootlegging is a serious problem, and it's one of the bigger initiators of the abuse that is inflicted among elders. It also leads to sexual abuse, domestic violence, child abuse, and child neglect. And many of our families do not know how to initiate that process of reporting, whether it come from community or family. The other thing is, if there's a repetitive problem with bootleggers committing these crimes, is there any ramifications for repeating these crimes, such as fines, just something that holds them accountable? Because in our view, the alcohol is what is the initiator or contributor that leads to all the crimes that we have discussed today. So I just wanted to kindly bring that about and raise our concerns with what we see. Thank you, Ashahat.
Yeah, and I gotta apologize for the task force. We're using my laptop to stream, and so I appreciate everybody's patience and just the amount of notifications. I'm trying to turn off everything and missing a few. But Andrea, thank you for the comment. I think we'll dive deeper into the conversation regarding alcoholism and bootlegging. We know that all stems from trauma. And an individual who has the addiction or sickness of alcoholism or substance abuse primarily numbs that pain and shame. And so we always want to take that step back in how we support and criminalize some of these initiatives. So I appreciate that comment, and we do see a high number of cases with the intersection with alcohol or substance abuse. So thank you for sharing that insight, and that's why it's critical we continue to partner, have data, and have this comprehensive approach. Appreciate you and your team there. So I think, thank you, Andrea, appreciate it. All right, so I think is that the last? So that's the last caller. I know, Shama, you wanted to have the final word, so we're gonna honor you and respect you, Ms. Bowman. Shema, you have the floor.
Kiaja, thank you. Just to comment on the last caller's concern. At some point a few years back, there was federal prosecution of a bootlegger, and that kind of stopped that in for a period of time. So I think that would be possible if you have someone that's always doing that. And then the other comment I would like to make is the caller before her. She has discussed something that I think would be very doable, because she's saying, let's have the statistics, which are the crimes that are mostly charged, that are being committed now, and let's focus on those instead of trying to amend the whole Title 17. We could do it in a way that we discuss everything as we go along. The last discussion we had as a group was in January, and here we are in June. That's why my comment this morning was, I did not know any of and all of these things that were being proposed that Mr. Barnett spoke about, and we never really discussed them. And Mr. Henio did say that we were going along in a way that we were discussing the criminal statutes, and then we were working well together. And then that stopped for a while, and this is the first time we're getting together as a group, and it has to be with your committee. And if you had been involved with or had some members in our group before, you would have known some of the discussions we had on the statutes. And then the last thing I want to say is I have 3 case handlers and myself. I have 6 vacancies, and we're covering 12 courts. That is why I have to really make time to participate in these types of discussions, because I seem to be the only public defender that has been having any input. And I just want to mention that I am also a survivor, and I am not going to discuss any details about what I went through, but I have been able to go through counseling, and I've left all that behind. And also I have had 3 murders in my own family, 2 of which have never been solved. So I also consider myself a survivor of those. I will never see myself as a victim, because I've been able to do my work and overcome all the sadness and grieving and everything that I went through. I left that back a long time ago. And so I can do this work, and somebody has to do it. And it's statutory. Public Defender's program is statutory to provide defense services to defendants. That doesn't say that all of our components are important. The public defender, the prosecutor, and the judges. We need to all work together, and I've always done that. I don't think I've ever really taken sides. I mean, I've seen bad people come through too, and I've had to represent some of them, but I've been able to do my work because of the counseling and all of that I went through in my history. So I just want you to know that I'm not just one-sided for the defense. I can see the whole picture. And that's because I've done this work, like I said, for over 30 years. Anyway, thank you, Shiaji. That's all I need to say.
Oh, Shema, I appreciate that reflection and your point of view. So we look forward to the Public Defender's Office reviewing these amendments, because I am stating for the record here that I'm going to submit for a legislation, and I did let Legislative Council delaying, or like the 6 to 9 months normal time to wait for a legislation will not fly, and we'll continue to have these discussions. And families, they want to testify, they want to continue to march to raise awareness. So the Navajo Nation does have a duty to protect our people. And so we want a comprehensive approach to do that work. So I appreciate your insight and I understand your limitations. So hopefully during this budget process, we could work with the Office of President and Vice President, and they will give you the funds needed or recommend the funds needed so you could start doing some contract work to help you with your capacity and for Navajo Nation to fulfill our obligation. So appreciate it. Thank you so much. Sorry again, because we usually do a lot of chatting, but this one just happens, everybody's seeing your chat. Any final words from advocates here? Did you, we're gonna end in a prayer.
Yes.
I just want to say, the Office of the Prosecutor, you're part of that tribal community response plan. Now seeing that you may not be involved till there's an actual case, let's have a conversation if what advocates then should be part of that. We're talking to like behavioral health, Division for Children and Family Services who have advocates, but so I think it's just the rationale, the logical rationale, because that's putting a lot of pressure on your advocates when you're not notified when there's a missing person. And that's when we need that rapid response. So I just want to state that for a follow-up. So I'll give the floor to Shada Clarissa. She wanted to provide a prayer in closing.
Before we close,
Sure.
before you do your prayer, I just wanted to say that I look forward to working with your committee to do everything necessary to close any gaps that there might be. And working on Title 17 is going to be a real big one that I'd like to see you guys' engagement and support in, and also with the role of the victim witness advocates. Thank you.
Sure.
Yeah.
And so this is gonna be similar to what we did with the Victim Rights Act, where we just couldn't wait any longer. And so everybody's accountable. I know we're all busy, but hearing the stories and knowing that statute of limitations has run out and the feds have declined, I can't get past that as a leadership if I know I could change laws and we have the support
Absolutely.
of the
Yes.
So appreciate it.
Yes.
So Shade, you have the floor, Clarissa, to end us with prayer. Appreciate you.
Good morning. This is Clarissa Begay. I'm with the Speaker's Office, and I just want to make a comment that, you know, us that are all here to work together to make this possible, we have to have a faith. And I'm asking each and every one of you now to just put your heart right now in this moment to the Lord, and He is the one that will make it possible for us. We can work as much as we can work as hard as we can, but you know what? It's the Lord that will make it possible for us, because I'm a strong believer in the Lord. And so with that, I'll leave that with you, and I'm going to go ahead and say prayer now. My Father in heaven, Lord Jesus, I'm here before you with my colleagues, with the team from on this Zoom, Lord God. Hear us, Lord God, Father Jesus. Hear of us what we're trying to do here, Lord God. Open doors for us, Lord God, Father. And hear our cries. Hear us of what we're trying to do here for our people, our Navajo people, and for the tribes across the world, Lord God, Father Jesus. And for the Navajo Nation, Lord God, we want to update and change the laws in Title 17. Hear my prayers and hear my colleagues' prayers, that we may change the laws and that the executive, legislative, and judicial will be able to work together and collaborate to make this possible as soon as possible, Lord God, Father, and help the MMDR task force members, Lord God, that we will work together well and to make this possible for our people, for our children, for our elders, and for us to just, we love you, Lord God. We love you. We praise you, Lord God, and forgive us of our sins today, Lord God, Father Jesus. And I say this in your sweet, sweet name, Jesus. Amen.
appreciate the request to end in prayer, Shade. So we'll move forward in a good, positive way. I also want to state that maybe we would sponsor through the Office of the Speaker and working with our traditional practitioners and bring out the war shields. And so that could be something, it's an open invitation, but that could be something in the future so that we continue to protect our mind, body, and spirit and bring that energy in to continue to protect our people, you know, in a way that is needed. So Tatiana, if you could add that in, because that's the way we have been guided in the past, and it may be a way to continue to have this dialogue with each other. Appreciate all of you. We're gonna end the call at 10:34. Appreciate all of you, and I think our next call will be
June 17th.
June 17th is our next call, and I believe the New Mexico Department of Justice will be on the call